click OK to accept it. And now I'll introduce our speaker. Jason Blazakis is a professor at the Middlebury Institute of International Studies, where he focuses on threat financing, sanctions, violent extremism, and special operations related research. He is also the director of the MIIS's Center on Terrorism, Extremism, and Counterterrorism, where he directs research on domestic terrorism, terrorism finance, recruitment, propaganda, and the use of special operations to counter transnational threats. And Jason, you can take it away.
Great. Thank you for the introduction, Erin. It's wonderful to be here. I'm going to try to share my screen because I actually have a PowerPoint. Let's see if I can do this correctly. I apologize as you bear with me to do this, and hopefully everybody can see the screen. So today's talk, I was asked to speak about President Trump's deployment of terrorism designations with an eye towards focusing on two specific actions that have occurred over the last 14 months, the designations of the Islamic Revolutionary Guard Corps, Iranian entity, and the Russian Imperial movement, a transnational based organization operating out of Russia. Two very different kinds of organizations, but I think it really makes for an interesting conversation, and I call it really a tale of two designations. And interestingly, they occurred and transpired nearly 1 year apart from one another as well. So here's the agenda. I always chastise my students to actually put together either a bluff bottom line up front or agenda when speaking. I almost forgot to do that myself, but this is what we're going to cover in this talk. My hope is I'll speak for 20 to 30 minutes, and then we'll have a half hour for discussion. Like you all, I have Zoom fatigue, and I really don't want to just hear myself speak the entire time. So here's the agenda. First, going to go over some of the background related to competent authorities in the United States who are the lead agencies or departments for sanctioning terrorists in the United States. I think it's important to provide that context before jumping into the details related to the IRGC and the Russian Imperial movement. Second, we're going to focus specifically on State Department's legal authorities. Both the IRGC FTO designation and the Russian Imperial Movement EO designation were carried out pursuant to the State Department's legal authorities. Then we'll talk about the consequences associated with a terrorist designation. And then we'll start going into a look at the IRGC designation. What does it mean? Does it have any impact? And then we'll go look at the Russian Imperial Movement designation. And then I'll leave you with a few concluding thoughts. And then hopefully we'll have a robust discussion related to questions and answers you may have pursuant to this presentation or anything related to the sanctions more generally. So, who designates terrorists in the United States? On the left-hand side of the screen, you see the building of the U.S. Department of Treasury. The Treasury Department is one of the two competent authorities in the United States to sanction terrorists. Treasury primarily uses Executive Order 13224 to designate, quote, specially designated global terrorists. That's the primary tool. Treasury, and within Treasury, it's the Office of Foreign Assets Controls that carry out designations pursuant to that legal authority. On the right-hand side of the screen, you see the Department of State's building. Not a good-looking building. Unlike the Treasury Department, it has some pizzazz to it. The State Department's very brutal-esque architecture. The State Department uses two legal authorities. The State Department primarily uses the FTO, Foreign Terrorist Organization Designation Authority, pursuant to the Immigration and Nationality Act, to sanction organizations, and shares authority with the Treasury Department to sanction individuals and entities pursuant to Executive Order 13224. So if you take nothing else from this talk, I want you to understand that Executive Order 13224 is an authority used by both the State Department and Treasury Department. What are states' authorities to designate terrorists, and what's the relevant legal criteria? I have a much longer presentation about the State Department and the Treasury Department's process of sanctioning organizations and individuals. So I will just be brief and go over the State Departments, not Treasuries. But there is significant overlap between the two. Now, the State Department, as I mentioned before, designates FTOs pursuant to Section 219 of the Immigration and Nationality Act. When you're thinking about what goes into and what does the State Department have to prove to designate an organization, generally there are three criteria. The first is the organization has to be foreign-based. The organization has to have its overseas operations primarily conducted outside of the territory of the United States. The organization's leaders have to be generally based outside the United States. The organization's encampments generally would be outside the United States. So this is what the United States Department of State calls the foreignness prong. The State Department's not in the business of sanctioning domestic entities as terrorists. And I think we could have a really good conversation and questions and answers about why that is and whether that should be the case. The second criteria is the organization has to engage in terrorist activity or retain some kind of capacity to engage in terrorist activity and have some kind of intent. So generally speaking, the State Department list has 69 organizations on it today. You have 69 foreign terrorist organizations. All those organizations at some point in time have actually carried out an attack. Now, the State Department can designate groups if they've not carried out an attack, if the State Department has assessed that they have the capacity. For instance, they have the arms and they have the intent. They have some kind of bad feeling towards the United States that they may be rhetorically saying things about the United States that in and of itself wouldn't be sufficient unless they also have a capability. The third criteria is that the organization is carrying out terrorist activity that is a threat to U.S. national security interests. And that essentially means that the terrorist attack in some fashion has affected foreign policy, defense, or economic interests. It's very broad in scope. Now, the State Department also can designate under another legal authority, and I've mentioned it up top, and that's Executive Order 13224, which provides the Departments of State and Treasury pursuant to the International Emergency Economics Power Act, IEPA, which gives the president the authority to declare national emergencies and carry out executive orders in the context of national emergency. And that's why this executive order exists. This executive order came to fruition shortly after 9/11. The FTO designation process for the State Department was put in place in the first batch of FTOs were designated in 1997. So Executive Order 13224 is a younger legal authority. And it allows the Secretary of State to designate both organizations and individuals. So Executive Order 13224 expanded the scope of the powers of both the Treasury Department, because Treasury Department was not obviously in possession of this executive order until it was created, but also provided an avenue to go after individuals, specifically individuals for the State Department who are carrying out actual operations themselves or directing others to carry out operations. Now, interestingly, and this is really, I think, connected to the specifics related to the Russian Imperial movement, there was a move by the Trump administration, and I would say it was a very good move by the administration to modernize is what they called the Executive Order 13224. Essentially, they updated that executive order to essentially conform with the threats and to also provide, because obviously threats have changed since 2001. There's been an evolution, particularly in the context of white supremacists related to terror. And that modernization provided the State Department to explicitly go after leaders of groups. And what the State Department had to illustrate was simply the fact that the individual was the leader of the group, that the individual just wasn't the leader of the group directing activity. So in the context of developing the dossier of evidence, that made it easier for the State Department to go after individuals who were acknowledged leaders of an organization. And that comes into play in a very robust manner related to the Russian Imperial movement designation. So the last slide before we get into IRGC and RIM to provide you this context, because I think this context is very important, is why bother to sanction groups to begin with? Why do it? For FTO designations, there are an array of consequences related to the designation. The first is essentially that there is an asset freeze put into place. Because of the designation, U.S. financial institutions are obliged to essentially block transactions that may be benefiting designated organizations. A second consequence is if it is known that an individual is part of an FTO, they are inadmissible to the United States. So there is immigration-related nexus to the designation. And if they are already in the United States, and then it becomes known that they're part of an FTO, they are deportable. Or if they're associated, provide some level of support to an FTO, they will be deported from the United States. Thirdly, and this is perhaps the most important aspect of an FTO designations, it provides the ability for the Department of Justice to prosecute individuals who may be based in the United States or elsewhere who are trying to provide material support to that designated actor. A lot of people have it in their minds that a designation will only lead to some kind of asset freeze and that's it. But in the United States, there's this nexus between the FTO designation and the ability to prosecute individuals who try to provide material support. So let's say Al-Qaeda wasn't designated as an FTO. It would be much more difficult to prosecute individuals who try to provide material support to FTO, like Al-Qaeda, if it weren't designated. So, and I would say this particular aspect of the counterterrorism toolkit is really important. If you go look at stats, nearly 50% of all US counterterrorism related prosecutions are for individuals who try to provide some kind of form of material support to a designated foreign terrorist organization. If you try to do that as an individual, you could end up behind bars for 20 years. And the EO designations, there's a lot of similarity. I just want to point out the last bullet on the right-hand side because I think it's really important to understand this, that pursuant to Executive Order 13224, the Department of State is given what we call the primary authority, and then the Treasury Department has a derivative or secondary authority. So it's essentially, if the Treasury Department wants to use its Executive Order 13224 tool, there needs to be an underlying designation already in place. Generally, it's by the Department of State, but doesn't always have to be. It could be linked to one of the Treasury Department's listings of an individual. But generally speaking, there's going to need to be a group designation for Treasury if it wanted to go after, say, a financier within that group. They wouldn't be able to do that unless the State Department, say, designated the Russian Imperial movement. The Russian Imperial movement designation now by the State Department opens up the aperture for Treasury, for instance, to go after individuals who may be financiers associated with the Russian Imperial movement. So the State Department designations under Executive Order 13224 are really important for the Treasury Department. So if there's a way to kind of simplify this slide for you, on the left-hand side of the screen, I would say DOJ is one of the primary benefactors for a State Department FTO designation because of the material support prosecutions. And on the right-hand side of the screen, Executive Order 13224 designations by the Department of State are really important for Treasury because it opens up their own tools. So one of the more controversial designations since I've been tracking sanctions of FTOs is the sanction of the Islamic Revolutionary Guard Corps. And just to provide you some context, I used to be the head of the Department of State office, essentially from 2008 to August of 2018, that was essentially dedicated to labeling organizations as FTOs. So I have a lot of direct history here. And I will say also up front, the idea of possibly designating the IRGC as an FTO has come up in previous administrations. It was discussed during the Bush administration. It was discussed in the Obama administration. And for a lot of good reasons in the end, ultimately those administrations chose not to label the IRGC as an FTO. Now that changed when the administration, the Trump administration, decided to use that tool on April 8th of 2019 to label the IRGC as an FTO. And I penned a piece with one of my old bosses, Ambassador Daniel Benjamin, about why we thought the designation was pointless yet dangerous. And I have the perspective that the IRGC designation as an FTO was pointless for a few reasons. First, Iran as a country has been sanctioned as a state sponsor of terrorism since 1984. So it has, pursuant to US law, has had its property and some assets frozen for over 30 years, about 35, 37 years before this IRGC designation. And that's a pretty broad authority. And to take a step back in terms of sanctions, sanctions are designed generally to be preventative, and they are not designed to be punitive. So as you think about the IRGC designation as an FTO, I think it's important to think about the context of the impact and whether or not the action had some preventative aspect to it, or was it punitive? I would argue it's punitive because you have A, Iran already designated since 1984. B, the IRGC itself was designated by the US Department of Treasury pursuant to Executive Order 13224 in 2017. Now, it was designated by the Treasury Department for providing material support to already designated entities, groups like Hezbollah, for instance. And this has always been an important line and distinction the US government has tried to make in the context of using its legal authorities, particularly against entities using the FTO tool. And that is, a state generally is viewed as perhaps providing support to terrorist actors, and there are a lot of states that do that. Some, like Iran, are state sponsors of terror. Others aren't. And we can go into a discussion about why, if you are interested in, like, why is, say, Pakistan not a state sponsor of terrorism? IRGC is providing support to groups like Hezbollah. It's providing support to, say, the Houthi rebels in Yemen. The distinction is important because the IRGC, from the US perspective, wasn't, say, while we could definitely link IRGC to direct acts of terrorism, the US wasn't saying it was directly carrying out acts of terrorism until essentially the 2019 determination. Now, you may think that this is a distinction without a difference, but it's a really important one in terms of tools and how we think about the use of sanctions. And until the IRGC designation, you hadn't seen a foreign terrorist organization added to the list that was a state body. So now you essentially set the precedent of potentially opening up a Pandora's box of state entities that now could be added to the FTO list. So I always have felt that it's really important to draw a line between transnational actors who can be labeled as terrorists and state entities that could be directly related and designated as a terrorist actor. So that line's been crossed, and I think that's problematic. Also, ancillary to the conversation, IRGC have been designated pursuant to numerous executive orders. There are a couple there related to human rights and non-proliferation related activities. And then the special force component within the IRGC was designated pursuant to Executive Order 13224, providing support to groups like Hezbollah in 2007. This is all to say that IRGC is already subject to asset freezes. When the designation was unveiled by the Trump administration, you had some individuals like Brian Hook say that this is going to open up tools for the Department of Justice to prosecute individuals for material support to IRGC. He said it would be happening. If you look at the transcripts, it seemed like there would be some kind of imminent related prosecutions pursuant to that. There haven't been any. And there's also a bit of a misnomer. You can prosecute individuals for providing support to designated Executive Order 13224 entities. And a really good example of that is the Taliban. The Taliban is not an FTO, but there have been individuals like John Walker Lynn, the so-called American Taliban, who was prosecuted for providing material support to the Taliban in terms of providing himself as a tool to the Taliban. So from sort of the essence of this crossed a line in terms of merging essentially states entities into the FTO list, which is a dangerous maneuver. And two, there was no practical impact related to designation. And in fact, as you see on the right-hand side of the screen, I argue with Dan Benjamin in Time Magazine that it was a dangerous decision. It set a precedent. Where will the Department of State go in the future with using this tool against state entities? You saw after the State Department's announcement of the designation on April 8th that Iran was quick to act and label United States Army, and many others as terrorists. And that set a tit for tat that is really unhelpful. I argued with Dan that the piece, the decision to add the group to the list, put U.S. soldiers and other U.S. assets and our allies' assets at risk because Iran would likely respond. And if you look at Iran's activities, I think you could argue they became more belligerent shortly after the designation of the IRGC as a FTO. You saw in May of 2019, I believe, the IRGC was, according to the United States, alleged to have been involved in some limpet mine attacks in the Gulf of Oman. And then, of course, at the beginning of this year, late last year, you saw this spike in activity, direct activity between the United States and the IRGC. U.S. Embassy was under siege, likely at the direction of IRGC using their proxies like Kataib Hezbollah to surround the United States Embassy. And then, of course, you have the now new thinking that maybe the FTO designation somehow provided some kind of kinetic basis for the targeting of the IRGC Quds Force leader, for instance, Qasem Soleimani. And I just want to be clear, when I was at the Department of State in the office that did these designations, we always made it clear that there is no correlation between the targeting of individuals who are associated with FTOs and the sanction tool. The sanction tool does not provide the legal authority for going after individuals who are part of groups. Those are a separate set of determinations, but the IRGC designation, and what you'll see in 2 slides, I think the Trump administration may have used as one of the bases for targeting an individual within the IRGC. On the left-hand side of the screen, you see U.S. Embassy under siege. This is from December. You see the bottom right side of the screen, U.S. Embassy in the green zone was subject to some rocket attacks in January of 2020, of course, have been subject to green zone attacks likely associated with IRGC's proxies, Kataib Hezbollah and Asab al-Haq, for a great long period of time, even predating the IRGC's FTO designation. And then, of course, on the right-hand top side of the screen, you see the Middlebury Institute working with Planet, an organization, Commercial Imagery Lab, that actually depicted the IRGC Quds Force likely strike against U.S. assets in Iraq post-assassination of Qasem Soleimani. So this was the response to Soleimani's death, which, if you take a look at the U.S. justification for that act, the last clause that you see specifies that the killing of Soleimani, the head of the IRGC Quds Force, a U.S. designated foreign terrorist organization. So that leaves the impression with people that the targeting of Soleimani was somehow directly linked to the organization being designated as an FTO. And if you go back a few slides, to me, it's a really dangerous precedent that the tool, a sanction tool, can be used in a manner to perhaps give the impression to the public that it's being used as a tool to kill individuals that may be associated with that designated FTO. I skipped over and didn't really get into great detail about what the IRGC is. I just made the assumption that most of you know what it is. Organization created in 1979, essentially designed to protect the political system of Iran. And it's an entity that is quite significant in numbers. You have 250,000 individuals that are part of the IRGC. And this is another reason why it's dangerous, the action to designate the group as an FTO. Unrolling and unpacking an FTO to delist it at some point. Let's say in 10, 15 years, the United States and Iran become simpatico. The idea now that you have 250,000 individuals and more over time who are going to be implicated as being part of an FTO could have profound impact on the ability of the United States and Iran to negotiate any kind of future rapprochement. And we've seen this before in the context of other groups. If you take a label to an organization like this, it could have profound impact in terms of rapprochement. And you're seeing it in the context of negotiations with the Taliban as well, who's designated under a separate authority, EO 13224. And I apologize, you may be hearing my dog bark. I should have mentioned that up front. That's why I'm wearing the headphones. If you hear barking, I apologize. So I want to transition to the Russian Imperial movement because I'm already spoken longer than I thought I would. The State Department in the Trump administration, for all the criticism it's received in the context of its deployment of sanctions, I think the State Department's designation of the Russian Imperial movement is objectively a really good maneuver. And I say it's a good maneuver for quite a few reasons. Here you see essentially some of the individuals on the left-hand side of the screen within the Russian Imperial movement who are now designated. On the right-hand side of the screen, you see the interesting picture of the Russian Imperial movement emblem over the Russian Federation flag. To the right of that flag, you see an individual standing. His name is Matthew Heimbach. He's wearing, ironically, a Lebanese Hezbollah t-shirt. Now, Matthew Heimbach is a former white supremacist. He says that he is no longer engaged in the movement. He's distanced himself from the movement. He's a US-based person who was one of the individuals who was the organizers of the Unite the Right rally. And Heimbach was part of a group called the Traditionalist Workers' Party. Now, I find it really interesting that you see these connections. And this is something I think if you look at the radical right in the United States today, increasingly you're seeing that the radical right has these connections to foreign-based entities, groups like the Russian Imperial movement. Now, before going into the specifics of the State Department designation, I think it is probably worthwhile, because this is a more obscure organization than the IRGC, to provide just some context about what kind of organization it is. The Russian Imperial movement is a ultra-nationalist and paramilitary group that essentially believes that Russia should go back to a monarchy in the days of imperial rule, going back to the days of Nicholas II. And they are fighting for that first and foremost. So they look at the Russian Federation today as not being a sufficient form of government. So they actually don't hold people like Vladimir Putin in high regard, because obviously he's not a monarchist. And the organization is trying to fight from what they say against globalization, multiculturalism, and generally liberalism. And they do have that nationalist bent. And you've seen them in places like Ukraine, trying to fight against the Ukrainians to try to restore Russia's control of territory in Ukraine, and not just Crimea, but also in the Donbas region of Ukraine. And then you also have the organization say to be a member of the Russian Imperial movement, you have to be part of the Russian Orthodox Church and conform to the group's view that it's important to restore the monarchy in Russia. Now, you may be thinking, is this a white supremacist group? It's not a conventional white supremacist organization, but it certainly is anti-Semitic. And it does have a history of working with individuals like Matthew Heimbach, who was a white supremacist. And you have individuals within the milieu of the organization that certainly glom on to white supremacist related kind of thinking. Particularly as it relates to that sort of anti-Semitic bent. But it's not traditionally a white supremacist type organization or a neo-Nazi-like organization, because it does have those ultra-nationalist overtones to it. But it was still a really impactful designation. And the State Department said it was precedential in that it was an organization sanctioned for essentially being an organization that supported white supremacists. And if you look at the State Department's press release related to the designation of the Russian Imperial movement, the State Department highlighted the fact that the Russian Imperial movement provided essentially training to two individuals who carried out attacks in Sweden. And those individuals were devout neo-Nazis, and this is in the time period of 2016. By providing the training to the organization, or the individuals that carried out the Swedish attack, the organization then really met well the State Department's legal criteria for designation. And at the same time, when the State Department designated the Russian Imperial movement in April 6th of 2020, it also designated 3 individuals within the organization. Vorobiev, who is the leader of the Russian Imperial movement. He's the titular head of the group. Gariev, who is the head of the Russian Imperial Legion, which is essentially sort of the militant and paramilitary force within the Russian Imperial movement, and Trushkalev, another senior figure within the group. And when the State Department announced the designation of RIM and its leaders, the State Department said it was able to do that because of the new executive order that I mentioned up top. The new executive order essentially was the modernization of EO 13224. EO 13224 was updated to provide the State Department the authority to go after individuals who are leadership figures within groups. And that's why they're able to sanction those 3 individuals perhaps as quickly as they did. And this is an important action because it was the first kind of far-right group that had a tinge of white supremacy sanctioned pursuant to the State Department's legal authorities. So it's important in that sense. A lot of people have questioned, though, why wasn't the group made an FTO? And I think that's a really good question because I do feel it's an organization that probably would meet the FTO designation criteria that I laid out in the earlier slides. And if you look at that list, you have 69 groups on it. And none of those organizations on the list unfortunately have any kind of connection to a white supremacy kind of movement whatsoever. Now, the white supremacy movement is really diverse, but there are certainly transnational components to it. But as probably most of us think about white supremacy challenges today and think about the panoply of organizations that are in that milieu, neo-Nazi organizations like the Atomwaffen Division, for instance, they have this domestic connection that may make it tricky for the State Department to use the FTO tool. That's not really the case with the Russian Imperial movement. It's a group that it's obviously based in Russia. It's an organization the State Department noted had active training camps outside of the confines of St. Petersburg, an organization that provided training that led to the commission of attack in Sweden. The United States Department of State said in the press release that those activities, those terrorist activities, were a threat to U.S. national security interests. And those same criteria really do apply to the FTO designation as well. I think it was a really important designation, but I think the State Department could have taken that next step also and made it an FTO designation, and that would have had more impact. So what are my concluding thoughts about this set of designations? Now, obviously, I think the designation, borrowing from Dickens here, I think the designation of the Russian Imperial movement was an important act by the State Department. It was the first group designated by either state or treasury under any legal authority, and while it was only under Executive Order 13224, it was a precedential action. Essentially said the United States is now tracking white supremacist related entities, and they're on notice and they could be designated in the future. And that is a really important statement, particularly because it hadn't been made before. So, I absolutely give credit to the administration for doing that. On the flip side, the 2019 action of the IRGC, admittedly, it met the legal criteria. And I'm not gonna, if there's a question in the queue about, well, doesn't IRGC meet the legal criteria for an FTO designation? Sure, yeah, it does, no question. There's no question in mind it does. But I think all designations generally have to be examined for whether or not they meet the policy objectives of the United States government. And I think I laid out the case that the IRGC really didn't have any benefit in terms of the FTO designation. So I found that designation to be lacking. The last thing I will say is there's been a lot of chatter in this administration about using sanctions as a tool. And as someone who's a practitioner who has actually thought about these issues deeply and who has actually been involved in sanctioning individuals and organizations, I think we're at a point where perhaps there is sanctions overload, that these tools perhaps are not being used in the way that they should have been originally used for, and that is to prevent things from happening as opposed to being used in a punitive fashion. And we have seen rhetoric in which the administration, for instance, has said, well, we're going to designate groups like the Egyptian Muslim Brotherhood, or we're going to designate the Mexican cartels, or we're going to designate Antifa as terrorist groups. And I think using that rhetoric is problematic because A, it tips the hand, but B, it may put the State Department and Treasury Department in a box where the senior leader in government is saying, we're going to sanction somebody, and then in the end, the tool is not used or it's walked back. I have some concern about the politicization of sanctions as a tool. Now, sanctions have always been politicized, of course, but I think we're at a point where they're being politicized at an all-time high level, and that's really problematic. Just because you may have a meeting, say, with al-Sisi and talk about things related to Egypt, you shouldn't necessarily just promise that the Egyptian Muslim Brotherhood is going to be designated as an FTO, because there's a really deep process that has to be followed, a very deliberative process that has to be followed that meets legal criteria before that can happen. And then on the other side of the equation, saying that the tool is going to be used against inherently domestic-based entities like Antifa is particularly dangerous because there is no legal authority that exists today that allows for the United States Department of State, for instance, to designate domestic-based entities. So the notion of being able to designate Antifa is far-fetched. But at the same time, by saying it's going to happen, it actually sets a political overtone to a discussion that is really going to be difficult for the Departments of State and Treasury to have with their colleagues in the interagency process, because that tool simply does not exist. And the designation itself could be perceived as punitive, and perhaps even at worst, illegal, since it doesn't exist as a tool. So I've talked far too long. I would love to hear your questions. Here's my contact information. You can always find me via email. And Aaron, I think I'll turn it over to you, and I'll stop sharing my screen so I can take some questions, if that's okay.
That sounds excellent. So everyone, just remember, if you have a question for Jason, you're welcome to drop it to me in the chat, and I'll be moderating questions now. We do have a couple of questions right now in our chat. So you noted before that none of the FTOs can be considered white supremacist organizations. Can you kind of go into detail in terms of why we haven't seen any far-right organizations so designated? And I imagine you think that's an oversight.
Yeah, no, it definitely is. There needs to be, my perspective is there needs to be more effort put into the sanctioning of white supremacist groups using all the legal authorities that the United States possesses, existing legal authorities. So looking at the foreign-based networks, Executive Order 1334 and FTOs. In the context of the FTOs, I think there are a couple of reasons why this is happening, why there aren't designations of white supremacist groups happening. One, I think, is unfortunately political. I think there was a lot of reticence by the administration at the top levels within the administration to use the tool against white supremacist related organizations, this administration. Predating 2016, though, there were other administrations that didn't use the tool too. So I think to be even-handed, it was an area of space that was neglected. Today, I would say politically, before that, in the last administration, I think you could argue that after 9/11, the United States government had a hard pivot, essentially, thinking about essentially pre-9/11 nationalist separatist organizations as the primary terrorism threat to religious motivated, specifically Sunni or Salafi jihadist organizations, and Sunni jihadist organizations, particularly in the form of groups like Al-Qaeda, obviously from the national experience of 2001. And then when ISIS became more prevalent, particularly in 2013, 14, and 15, the focus of the United States was on those threats, the Al-Qaeda and ISIS threats during these, essentially from 2001 to 2015. That really gripped the Bush administration and the Obama administration, where all other targets, whether they were far right or far left targets, were generally not focused upon by the U.S. government. And I'm not talking just about the lack of use of sanctions, but more generally other counterterrorism tools, and thinking about, for instance, collection intelligence collection on these organizations that may be on the far right. So the United States was slow to pivot to the threat in the context of transitioning from essentially nationalists, separatist groups to religious groups, and now the United States generally has been slow to pivot to radical right-wing groups, which actually statistically perhaps are the most serious threat to U.S. citizens on U.S. soil. So I think this idea, the slow pivot, the lack of intelligence collection, the United States government may not be prioritizing, say, CIA or NSA intelligence collection against overseas white supremacist groups, or if they are, they've been slow to essentially take those platforms, whether human or technical platforms, and then target white supremacist groups because of the national experience related to 9/11. And the United States is a large bureaucracy and really slow to pivot to new threats. And that has implications for the State Department and Treasury Department in terms of using their tools. The State Department and Treasury Department need intelligence to sanction groups. They can't rely solely on open source information. They need to ideally corroborate open source information with intelligence so they can develop a robust dossier that allows for the designation of a foreign terrorist organization group to happen. So I think it's a mix of politics, intelligence, and lag time and bureaucracy, those combination of things that have led to fewer to no FTO designations of white supremacist groups. And I think that needs to change. I think there are quite a few groups based overseas that probably do meet legal criteria. And my hope is that perhaps intelligence collection is slowly happening, and maybe we'll see some additions in the future. But it's a great question. Thank you.
Thank you. So I'm going to be skipping through our questions list a bit because I have another question that kind of piggybacks well off of what we were just talking about. But we've talked about the difficulty of designating groups like Atomwaffen and far-right organizations. How would you assess the efficacy and ability to designate such a group that is domestic but has foreign analogs of some kind?
Yeah, so the United States Department of State has a specific memo that lays out when it may be difficult to designate an organization that has a domestic presence. And the Atomwaffen division most certainly has a domestic presence. Now, when the United States Department of State thinks about whether or not domestic presence would preclude them from designating a group as an FTO, the terminology is whether or not they have a significant domestic presence. So I think as the State Department evaluates Atomwaffen division, it's important to think about some of the sub-organizations and organizations that may have pledged loyalty to the core group, the Atomwaffen division that is primarily based in the United States, and whether or not you can make a creative argument that these subgroups like the Sonnenkrieg division, the Führerkrieg division, the Atomwaffen division in Deutschland, there's a new Atomwaffen division that was announced over the last few months in Russia, whether or not with these additions of these organizations, whether or not you could do an Atomwaffen division that speaks to these connectivities in these subgroups, and whether or not that would give you over the hurdle for meeting the legal criteria for designation. The second component of that question, I guess, would be, if the answer is no to that, can you designate those affiliated groups as FTOs separately, and then allude to the Atomwaffen division historical linkage in some way? I think the efficacy question is more challenging because efficacy speaks to effectiveness. So let's say the State Department did designate these groups. Would there be assets frozen? Would there be material support prosecutions linked to the designation? And I think the answer is quite possibly yes. There are linkages between the far right overseas and the far right United States. So if you were to go after some of these groups that pledged essentially affiliation to Atomwaffen division but are primarily based overseas, it may be a way to go after Atomwaffen division members in the United States for providing some kind of support to those organizations if there is a link between that individual in the United States and the overseas group, say like the Sonnenkrieg division. So it really will be contextual, it will really depend on each individual's connections. But we've seen with the Atomwaffen division that they certainly have had international connections. There was the case in Washington State of the Atomwaffen division member, for instance, having a connection to the Azov battalion. So you have those connections, and they do exist. And I think that even though it may not be able to go after Atomwaffen division domestically, going after some of those other organizations may open up the aperture for Department of Justice and FBI to go after material support related cases that they otherwise wouldn't be able to.
Okay, great. And kind of, people are very politely kind of providing questions that piggyback off of what you've already said, so that's fantastic. But what are your thoughts on having domestic terrorist-based statutes? Do you think this would be helpful or harmful to the U.S. government's ability to track and prevent domestic terrorism?
So I have written in a piece with Lawfare, for Lawfare with Mary McCord, who is a brilliant lawyer, worked at the Department of Justice and the National Security Division. And we produced a piece that we thought a domestic terrorism statute would be helpful. And I still actually have that position, that a domestic terrorism statute would provide important ways for the United States to essentially have additional charges for individuals who carry out acts of domestic terrorism. There is already a definition of domestic terrorism that's on the books, but there are no accompanying charges unless the individual uses a weapon of mass destruction, which is very broadly defined. It could be not just a chem, bioradiological, it could be an explosive device. Those individuals can be charged for acts of domestic terrorism. We need to be clear about that. But what is more difficult is going after individuals who may be providing material support or be carrying out small arms attacks. You know, a quintessential example I like to give is the case of Robert Bowers. Now, Robert Bowers, the individual who carried out the Tree of Life synagogue shooting in Pittsburgh, Pennsylvania, is going to be behind bars for quite some time, but he wasn't charged for an act of domestic terrorism. He used small arms, and from my perspective, what he did was an act of domestic terrorism. He was trying to use violence to make a political message and to create fear in an audience, and his audience was the Jewish community. So for that reason, I think you can use the authorities that define terrorism, add additional charges, and you would have a domestic terrorism statute that would have impact. I've also written in the past that the United States should designate domestic terrorist groups. I wrote a piece in 2018 on that, and my position's evolved over the last 2 years on this as I see the politicization of sanctions become more stark. I could just see if that had been implemented, if we had a domestic law that allowed for the sanction of domestic groups, I think that would make for a lot of organizations to be potentially put in harm's way that would be inappropriate for political reasons, not necessarily because they're carrying out, quote, acts of terrorism as defined under US law today. So my position's evolved. Now, any domestic terrorism statute needs to ensure that privacy and civil liberties are taken into consideration, because there were a lot of excesses, particularly in the 1960s, with programs like COINTELPRO, where the FBI was spying on individuals who were perceived to be threats to the state, and many of these individuals were simply fighting for civil rights. People like Martin Luther King were being spied on, and it was inappropriate use of authorities. And because of that program's been reined in, there's been a lot of reticence, understandably, about actually creating a domestic terrorism law. But if it's built in with civil liberties checks, and there is one particular bill that I think is really good about doing this that's been introduced in Congress by a member of California, Adam Schiff. He put a bill forward to actually create a domestic terrorism statute. A number of senators and members of Congress have. His bill actually builds in oversight through an entity called the Privacy and Civil Liberties Oversight Board, PCLOB for short. Essentially, after 2 years of implementation, the PCLOB will be reviewing on the rolling basis whether or not there was any overstepping by federal law enforcement authorities in terms of implementation of the domestic terrorism law. So from my perspective, building in that privacy, civil liberty oversight is particularly important in the context of a domestic terrorism statute, but I do think it's very important.
Okay, great, thank you. Kind of pivoting away from the domestic space and talking about the IRGC specifically, you mentioned that the IRGC doesn't itself commit terrorist attacks, but they do support those who commit terrorist attacks. Do you know, because I think there were some reports that they committed the attacks in India, Georgia, and Bangkok in February 2012. Is that a case you're familiar with, or?
So the State Department in the press release talked about terrorist plotting that the IRGC was engaged in. Some of these cases are not exactly clear about whether or not they were using cutouts or proxies to carry out the attacks. So one State Department press note on the designation talked about the 2011 attempted assassination of the Saudi ambassador in Washington, D.C. of being part of an IRGC plot. They commissioned that out to an individual by the name of Arab Ser. The plot was thankfully foiled. So the activities of IRGC really have been on that line for quite some time of whether or not they were directly versus carrying out the act itself or sponsoring and provided material support, logistics, know-how. I mean, I think it's a really important line to draw. Some of those cases, I think, the logistical network, the guidance, picking the individuals who would be involved in it. In that Saudi assassination, for instance, they were going to use the Zeta Mexican drug cartel to assassinate the Saudi ambassador. So they were thinking creatively about using a proxy. From my perspective, those acts are also somewhat old, resting the designation, say, on 2011 failed assassination plot that was uncovered by the Drug Enforcement Administration. And then the Thailand plot, and I think there was, the individual may have mentioned Georgia. Those are, 7 years from the time of the designation as well. So a good FTO designation needs to really look at sort of the activities carried out by the organization within the last 5 years, not really go back that far. And there are a lot of reasons for that. FTO designations are reviewed every 5 years. Going back too far calls into question whether or not the action is punitive versus preventative. But as I mentioned before, it's very clear to me also in terms of the legal criteria that the IRGC met the legal criteria. So I don't want to go too far down the road of like, did they this, did they do that? They certainly met the legal criteria. To me, that's moot. What's important is whether or not the action has impact and whether or not there'll be consequences that are problematic from a U.S. national security perspective because of the designation itself.
Sure. And kind of talking about the efficacy and utility of the designations, another question is, why would you argue that a designation against the Egyptian Muslim Brotherhood would be against U.S. interests?
I didn't argue necessarily that it would be against U.S. national interests. I think my primary argument is that the group doesn't meet the legal criteria. So if it doesn't meet the legal criteria, it shouldn't be designated. There is no credible evidence that the Egyptian Muslim Brotherhood has carried out acts of terrorism, full stop. I know from past experience, the Egyptian government has provided information to the United States government and made press announcements about EMB, Egyptian Muslim Brotherhood attacks. But generally, the Egyptians conflate attacks associated with ISIS in the Sinai with the Egyptian Muslim Brotherhood. So the Egyptian Muslim Brotherhood would be a bad group to designate because it doesn't meet the legal criteria. And even though the president promised the group would be designated as an FTO, more than 2 years later, we still haven't seen that happen. And the reason why is because it doesn't meet the legal criteria. So that's my primary argument. And you can't designate a group unless it meets those three criteria. And it's obviously a foreign organization, meets that criteria, right? But it doesn't carry out terrorist activity.
Sure. Well, that's all the questions we have, which is kind of this almost perfectly on time, unless anybody's frantically typing and will send me anything very quickly. But assuming that's all the questions that we have, Jason, thank you so much. I think this was a fantastic presentation.
Thank you, Aaron. My pleasure. Thank you, everybody, for listening.
So thank you everyone for joining us. If you have any further questions, you're certainly welcome to reach out to Jason, or you're welcome to reach out to START and we can pass your question on to him. Thank you for joining us today, and everyone have a wonderful day.